Welcome to this explainer. If you are focused on understanding the mechanics of modern business structures, well, you're in exactly the right place. Today, we're diving into a fascinating and honestly incredibly innovative legal entity that was born out of a 2016 reform in Mexican commercial law. It's called the Simplified Joint Stock Company, or as it's much more widely known by its Spanish acronym, the S.A.S. We're going to break down exactly what this structure is, why it was created in the first place, and the very strict rules that govern how you use it. But before we get into the nitty-gritty legal mechanics, let's start with a really fundamental question. Historically, when you hear the word company or society, what immediately comes to mind? A group of partners, right? For the longest time, the traditional assumption was that you absolutely needed multiple people to start a legally registered, protected business entity. So the question is, can one person, acting entirely alone, form a fully fledged legal company? The answer, thanks to the S.A.S, is a resounding yes. As legal scholar Ana Morelli Juarez Flores states, this social type is a capitalist and unimember society, since the exteriorization of the will of a single partner is enough. Think about how revolutionary that is for a solo entrepreneur. The will of a single person is now entirely sufficient to give life to a distinct legal entity that completely protects their personal assets. You don't need to go out and find a co-founder just to satisfy some outdated legal checklist anymore. So here is our roadmap for today. First, we'll meet the S.A.S. 2, rules of the game. 3, how to build it. 4, running your company. And 5, the fine print. Section 1, meet the S.A.S, breaking tradition. For decades, forming a commercial society meant a mandatory trip to a notary public. It was this paper-based bureaucratic nightmare. It involved substantial fees, and again, it required multiple partners. Well, the S.A.S completely rewrites that script. Literally no notary public is legally required to form an S.A.S. It is totally exempt from the requirement of a public deed. On top of that, the process is 100% telematic, meaning it's fully online, and of course, a unimember setup is explicitly allowed. It's truly designed for speed. Section 2, rules of the game, the boundaries. Now, the crucial catch here is that not everyone is allowed to just go start an S.A.S. The law explicitly states that shareholders in an S.A.S. cannot simultaneously be shareholders in another type of commercial society if their participation in that other society gives them control. But what does control actually mean in legal terms? Well, as defined by Article 2 of the Securities Market Law, it means you have the ability to impose decisions in general assemblies, or you hold over 50% of the voting rights, or you have the power to directly or indirectly dictate the administration and strategy of that other company. Basically, if you are already the boss somewhere else, you are disqualified from playing in the S.A.S. sandbox. This rule keeps the S.A.S. reserved for true, emerging entrepreneurs, not corporate giants looking for a quick legal loophole. And that brings us to the second massive boundary, the income cap, 6,783,425 pesos and 40 cents. That is the strict annual total income limit for an S.A.S. Now, this number is updated every January 1st to account for inflation, but the core rule remains exactly the same. If your company generates even one single peso over this limit, you are legally obligated to transform your S.A.S. into another type of traditional mercantile society. If you fail to do that, the shareholders instantly lose their limited liability shield and become personally, solidarily, and boundlessly responsible for the company's obligations. So growth is obviously good, but in an S.A.S., too much growth forces you out of the nest. Section 3, how to build it. Article 262. The actual constitution process is brilliantly stripped down to just 3 core actions on the Ministry of Economy's digital system. Step 1, you or your fellow shareholders must formally extern consent to form the society under the standard statutes provided by the digital system. Step 2, you must secure official authorization from the Ministry of Economy to use your chosen company name. And step 3, and listen, this is the absolute non-negotiable key to this whole telematic process, every single shareholder must possess a valid advanced electronic signature, which is known in Mexico as the e-firma. Without that e-firma, you cannot sign the digital social contract and the company literally cannot be born. Once you're inside the digital system, you have to build the company's legal DNA. Article 264 requires the company name, the personal names and addresses of the shareholders, their tax IDs or RFCs, and their emails. You also need to define the society's lifespan, the voting weight of the shares, and crucially, the specific object or purpose of the business. Once all that is submitted and electronically signed, it gets sent straight to the Public Registry of Commerce. And just like that, your company exists. Section 4, running your company, day-to-day operations. How power is wielded in your new S.A.S depends entirely on whether you're flying solo or teaming up. If you are a unimember S.A.S, so just you, the law drastically simplifies your life. You are simultaneously considered the supreme organ, meaning the assembly of shareholders, and you are automatically the administrator holding all legal representation. You make the call, you execute it. Boom. But if you have a multi-member S.A.S, traditional corporate democracy kicks back in. The assembly of shareholders makes decisions by majority vote. Interestingly, though, the law explicitly allows these meetings to be held remotely via electronic means, which is great. The assembly then elects one of its shareholders to act as the administrator. From a financial operations standpoint, the S.A.S comes with some really unique perks designed specifically to remove friction for startups. Notably, by virtue of Article 20, the S.A.S is uniquely exempt from the mandatory legal requirement to lock away 5% of its net profits annually in a reserve fund. That's a strict requirement for traditional societies, but the S.A.S skips it, keeping vital cash right in the startup's pocket where it belongs. Furthermore, the system mandates absolute simplicity. All shares have equal value and confer equal rights. Finally, unless you explicitly draft an agreement stating otherwise, the profits of the society are simply distributed in direct proportion to the shares each person holds. It's clean, it's fair, and it's simple. Section 5. The fine print. Warnings and obligations. Okay, so setting up the S.A.S online is amazingly fast. But the moment you get that digital registration, a clock starts ticking. Here are your strict post-setup obligations. First, all shares must be fully paid within exactly 1 year from the date the society is inscribed in the Public Registry of Commerce. Second, once that capital is fully paid, you must publish a formal notice on the Ministry of Economy's electronic system. And third, and this is the one that really catches people off guard, the administrator is legally mandated to publish a financial situation report on that exact same electronic system every single year. So what happens if you forget? Well, it's definitely not just a slap on the wrist. If the administrator fails to present that annual financial report for 2 consecutive fiscal years, the law mandates the forced dissolution of the society. Let that sink in for a second. The Ministry of Economy will actually initiate a declaration of non-compliance, and your company will be legally dismantled. The incredible flexibility you get at the start is completely balanced by these strict ongoing transparency requirements. You absolutely have to stay on top of the paperwork. Which leaves us with one final thought to ponder today. We've seen how the S removes the notary fees, fully embraces digital formation, and allows a single person to legally shield their personal assets. But we've also seen those strict income caps, the total ban on controlling other companies, and the very real threat of forced dissolution for missing your digital paperwork. So ask yourself, are the strict boundaries and the ongoing obligations of the S actually worth the unprecedented entrepreneurial freedom it grants? For thousands of new business owners, it's a resounding yes. But there's no denying it is a tool that demands respect and diligent management. Thank you so much for joining me on this deep dive. Keep learning, keep structuring those big ideas, and I'll see you in the next explainer.